much, Dr. Goodman. Good afternoon, everyone. I'm very pleased to welcome you all to the very first FBN session dealing with abortion law. The topic of abortion is a major issue in our country right now, and as many of you already know, abortion laws are actively in flux across the nation, including in Florida. We believe it's important to gain a firm understanding of the laws governing abortion, since they have a direct and powerful impact on clinical practice and healthcare policymaking. A nuanced appreciation of the law will also enable us to engage in a productive bioethical dialogue concerning abortion and abortion-related public policy. However, our purpose today here is not to debate the ethics of abortion, but rather to achieve a better grasp of its legal underpinnings. We are honored to be joined by three distinguished professors of law who are here today to guide us in this endeavor. Our first speaker today is Professor Danaya C. Wright. Professor Wright is a professor of constitutional law at the University of Florida's Levin College of Law. She speaks and has written extensively on constitutional issues, and her work has appeared in several book chapters and journals. Professor Wright also serves as co-director of the Center for Governmental Responsibility, where she spearheads the Equality of Rights and Social Justice Initiative, which focuses on equality of rights based on gender, sexual orientation, and gender identity and expression. Professor Wright, welcome.
Thank you very much. I wasn't sure if you were going to introduce all of us. I'm going to try to share my screen, and I hope that it works correctly. Share screen. And hopefully my buttons will actually work. So I'm going to begin talking really quickly about sort of the big picture constitutional framework of abortion jurisprudence in this country. And I'm going to start with a little bit about the history of abortion regulations. Many of you may know that at common law, abortion was not illegal if it was performed before quickening, but infanticide was illegal, and abortionists who inadvertently killed the mother would be condemned of murder. But starting about the mid-19th century, there was a movement by doctors to professionalize obstetrics and gynecology. And this led to criminalization in many states of abortion itself, the practice, whether pre or post quickening. Starting at the beginning of the 20th century, abortion was generally seen as the last resort of desperate women. And it was often, fallen women, fast women. And so criminalizing abortion was not seen necessarily as, it was actually seen as a good thing. It helped to prevent women from falling, I guess. But by mid-century, the 20th century, it really had shifted to being recognized as a practice that married women were using to limit their family size, right? Voluntary motherhood had been a call from the feminist movement throughout the 19th and 20th centuries. And the shift to recognizing it as something that more respectable women might do led to a gradual decriminalization of the process in a number of states, and a recognition of the right to things like contraception. Now, the Constitution has two provisions that are relevant to the abortion debate. The first is the Fifth Amendment of no person shall be deprived of life, liberty, or property without due process of law. It applies against the federal government, and we have a 14th Amendment analog that applies against the states. And I encourage you to look at that language because it's only about 10 words. Well, maybe it's more than that. Maybe it's 11 or 12 words. But those are not very many words to represent the ideas that will, or at least I should say the structure that the court is eventually going to, the scaffolding that they're going to put on to the due process clause. So the court's job is to put some meat on these bones. And we need to know, well, what is due process of law? So the Supreme Court has decided that due process of law certainly includes procedure, right? Technical requirements that laws have to actually be passed and signed by the executive. There's also fairness concerns with regard to what due process of law means, and that includes things like a notice, a hearing, an opportunity to be heard prior to a deprivation. And we call this procedural due process. On the other side, the court has also recognized that certain rights are more important than other rights, that they are just substantively more important. So things like speech rights, religious rights, the right to a jury trial, freedom from searches and seizures are seen to be so fundamental that government needs a really, really good reason to impair them. And so when we talk about due process of law, the idea behind the constitutional protection of due process is that government doesn't get to just act arbitrarily. Government cannot just go out and stop people from doing things, impair their liberty interests, unless they have a really good reason. So the Supreme Court has identified the enumerated rights in the Bill of Rights, like speech and religion and jury trial, as being fundamental. They've also recognized what I'm going to call unenumerated rights. So these are certain natural rights, perhaps, rights that have just been seen to be so important that they deserve the same kind of fundamental status that the enumerated rights get under the Constitution. And these include things like privacy, the right to vote, perhaps the right to a safe environment. And these are rights that, even though the words don't appear in the Constitution, the court has recognized them as being at the heart of what we mean by due process of law. So what the court has done in interpreting the due process clause is, and then they basically say that all other rights, normal rights, right, unimportant, not less important rights, get what we call rational basis treatment. So the structure of our due process clause is to recognize that there are certain fundamental rights, and those fundamental rights are really, really important. And if the government is going to interfere with them, the government has to have a compelling state reason to do so, and they must use the least restrictive means possible. And so generally speaking, the government better have a really good reason if it's going to interfere with fundamental rights. But on the non-fundamental rights side, government need merely have a legitimate reason, not arbitrary or capricious, and the means must be rationally related to the end. So as long as it generally makes sense, if a government law is interfering with a non-fundamental right, we pretty much say, yeah, that's okay, that's fine, government can do it. But if it's a fundamental right, no, government needs to have a really good reason. And this structure is very important, because starting in about a little over 100 years ago, the Lochner era, I have to talk about this era because I think everything that has happened in constitutional law ultimately kind of harkens back to this period. So there was this roughly 45-year period where the very conservative Supreme Court struck down hundreds of state and federal laws, minimum wage laws, maximum hours laws, health and safety laws. And they did so under this idea of the due process clause. The court said that liberty interest and that property interest that's protected against government interference by the due process clause, the individual's right to contract, the individual's right to work in substandard conditions, that is a fundamental right, and government cannot interfere with it. So we refer to this as an era of substantive economic due process. And this was a period when the court elevated economic interests, right, based on their theory of laissez-faire capitalism. They elevated these property rights to fundamental right status. And they really created this idea that, boy, this is a fundamental right, and the government has to have a really good reason to interfere with it. So labor laws, we're striking those down. Child labor laws, we're striking those down. Minimum hours, maximum hours, minimum wage laws, we're striking those down, because all of that interferes with economic rights. So during this period, there happened to be a couple of cases holding that certain intimate family decisions, such as sending a child to a private school or teaching a child a foreign language, the court said these are also fundamental liberty interests, but they didn't really go into that very much. Generally speaking, during this period, what I'm going to call morals legislation was generally deemed okay, right? You know, you had anti-abortion, anti-adultery, anti-fornication, anti-gambling, anti-lottery, anti-alcohol drugs or laws. all of these laws were seen as not raising constitutional problems because the right to an abortion or the right to commit adultery or the right, these were not seen as fundamental rights in the way that property and economic rights were. So the Lochner era did a couple of things. It created this idea of fundamental rights getting special treatment. The government has to have a really good reason if it's going to violate a fundamental right. But morals legislation, those were okay. They didn't interfere with fundamental rights particularly. And there was a really interesting juxtaposition. So what happens in 1936? Well, you have obviously a couple of world wars, or at least we're starting the Second World War. You've got utter meltdown of the economy as a result of the Depression and a lot of these laws. And starting in 1936, the Supreme Court backed away from this position that it had taken, this elevation of economic rights to fundamental right status. And it was partly Roosevelt's court packing plan. It was partly some of the ultra-conservative justices retired, but we get what's called the shift in time that saved nine, because really the Supreme Court had become completely out of touch with the progressive and New Deal era. And as a result of the demise of this, of Lochnerism, the court, anytime there's an allegation that we're reviving fundamental rights or fundamental economic rights, it's like, oh, you're reviving Lochnerism. And Lochner becomes this kind of constitutional third rail. You don't want to touch it because you had really activist conservative justices that were imposing their political viewpoint on everyone else. And so after 36, the court said, whatever, we're fine. Our bad. We're not going to do this. We're sorry. No, we went way too far. We're backing off. And economic legislation is fine. So between 36 and 65, we get this period of deference by the courts. Government can pass laws for economic grounds. Government can also have laws that interfere with what I'm going to call these sort of morals, individual liberty interests. So anti-contraception laws are fine, anti-abortion laws are fine. All of those kinds of laws are also deemed to be sort of, not fundamental rights. They don't interfere with fundamental rights. The court's taking a hands-off approach, and states can do what they want. But then we get to 1965, and this is probably the most important case. Griswold versus Connecticut was a case where the court struck down Connecticut's anti-contraception law. And the decision generated 6 opinions, 4 of which, for the majority, argued that there is a zone of privacy and that individuals, especially in intimate decision-making, have this privacy right. Now, privacy appears nowhere in the Constitution. And so there was a lot of give and take as to, well, exactly where does this due process, this privacy right come from? But they recognize it as being within the due process clause, a fundamental right that is protected under due process. Now, the dissenters went ballistic. They said, you're reviving substantive due process, right? By elevating the morals legislation type of thing to fundamental status, you're doing what you just got mad at us for doing in the economic sphere. And I think this case really stuck in the craw of conservative justices, and it still isn't stuck in the craw, because the conservatives backed away from elevating economic rights to a fundamental right status, but now the liberal majority on the court is going to town, where we could call them an activist court, raising a lot of rights to fundamental right status. And once you do that, it makes it much harder for government to regulate those rights. So, as you all know, Roe versus Wade was recognized as a fundamental right. The right to an abortion was recognized as a fundamental right under the privacy protections given in Griswold. And I always thought Roe was a great case because it made sense, right? So in the first trimester, no regulations by the state are permissible. In the second trimester, regulations are permissible, but only to protect the health and life of the mother. And then in the third trimester, which is post-viability, the state's interest in life permits a state, if it chooses, to regulate or even outlaw abortions. So the trimester structure made a certain amount of sense. Of course, immediately doctors, numerous critics of the opinion said, well, what's the first trimester? Is that 2 months and 28 days or 3 months and 5 days? Or, medical science is pushing the point of viability back. So there was a lot of critique of Roe versus Wade, as well as a critique of finding that abortion was something that should be given this fundamental rights status. So since 1965, the right to privacy has become very far-reaching. We see it with contraception, interracial marriage, the right to possess pornography, abortion, intimate sexual conduct, homosexual sexual conduct, same-sex marriage, the right to refuse medical treatment or to authorize medical treatment, the right to determine how to raise one's children. All of these rights have been recognized as falling under this privacy umbrella. And that is something that has been, I think most of us are in favor of the idea of privacy, right? We also have a bunch of statutory rights, like rights to privacy in our cell phones or our browser history or our medical records. And I don't think anybody really wants to give up those rights, right? So here's the problem. Well, okay, in 1992, there was a lot of pushback on Roe, and really the structure of abortion law shifted in Casey to affirm the fundamental right to an abortion, but they changed the regulatory framework to allow for sort of a viability, post-viability framework. So it's now a two-stage process. So during pre-viability, the state can regulate. Post-viability, they could regulate pre-viability, but only to protect a woman's right, and they could not unduly burden a woman's right to an abortion. Post-viability, the state can prohibit, even if it wants to. So Casey opened the door to a lot of extensive regulation early in the pregnancy, in the first trimester. It allowed for things like all of these endless trap laws. So spousal and parental consent requirements, 24-hour waiting periods, informed consent requirements, fetal heartbeat bills, the partial birth abortion bans, requiring fetal burial, the admitting privileges and clinic facility requirements. All of these laws started getting passed because Casey opened the door to these kinds of, death by 1,000 cuts regulations. You can regulate and regulate and regulate as long as you don't unduly burden the right, which is still deemed a fundamental right. So questions for the court with regard to these trap laws generally, but also with regard to abortion more broadly. Are any of these laws an undue burden on the constitutional right, or are they merely legitimate regulations? And, we can gladly talk about those. The court has gone back and forth, right? Sometimes they'll allow a 24-hour waiting period, then maybe the court shifts and they don't. It's really hard to reconcile the court's abortion jurisprudence in this area when we're talking about whether an abortion regulation unduly burdens a woman's right to have an abortion. But all of the cases until now, basically, until this case, have recognized that abortion is a fundamental right. It's just really a matter of how much regulation are we going to allow on it. So the case that's before the court right now, Dobbs versus Jackson's Women's Health Organization, prohibits abortions after 15 weeks. So this is way earlier than that post-viability, pre-viability shift that Casey recognized. So what is the court going to do? And this is where I think my colleagues on this panel and I may disagree. So I think we have the nuclear option. And so the nuclear option that the court may do, and I think Justice Thomas has supported it, is to reverse and reject the right to privacy altogether. In other words, just get rid of that right to privacy. Privacy doesn't appear in the Constitution. It's constitutionally illegitimate. And it's really an action. It would be just like what we did with the Lochner era. Just back away and say, no, we were wrong. If you want privacy, you need to get it in the Constitution through an Article 5 amendment. That's the nuclear option. Then I think we have the surgical drone strike option. And I'm telling you all of this because when the court decides, I want you to be able to like read it and say, oh, I know which one they did. The surgical drone strike option would really be to remove abortion itself from under the privacy umbrella, but leave everything else. Now that's going to be kind of hard, I think. I do think that's going to be hard. Probably what they're going to do, but how do you distinguish a person's decision to have an abortion from a decision to have a vasectomy, which will remain under the privacy umbrella? How do you take it out without ultimately unraveling that whole idea of privacy as a fundamental right? And the third option, which is what they've been doing so far, and they may continue to do that, is the landmine option. And that's basically uphold the right in theory, but rule that various restrictions are not undue burdens, death by 1,000 cuts, keep allowing more and more and more and more regulations, put up so many barriers that the right is no longer meaningfully exercisable, but you're still acknowledging that privacy is a legitimate liberty interest and that abortion is a fundamental right under that privacy umbrella. So I think other safe harbors may exist, but I want you to sort of be aware of at least those three choices. So I'm going to stop and turn it over to my colleagues. Oh, and I have to stop my share.
Thank you so much, Professor Wright. I'm going to take a couple of questions right now. If anybody has, in between the speakers, happy to take some questions and then we'll revisit any questions we don't get to at the end. Feel free to, in the chat or the Q&A box, to add anything you're wondering.
I can tell you that was a very, very fast.
No, thank you so much, Professor Wright. That was a very illuminating, fantastic presentation, packed with a lot of fantastic information. So see if anybody has any questions before we go on. Okay, here we go. Okay, Kathy says, awesome talk.
And then in the chat, we have, what would happen to the practice of medicine if the Supreme Court overturns Roe versus Wade? Mm-hmm. That's a really good question, right? I mean, I think the problem is, and I know Caroline may have a lot more to say about this, is can you separate the decision to have an abortion and the medical practice that's involved with that from all the other medical procedures that we clearly view as private decisions? So I don't know, why government doesn't get involved and tell you how to, what kind of admitting privileges you need if you're a dermatologist and you're going to take a mole off someone, right? But they're telling you what you have to do for this particular procedure. And I get it, there's a lot involved in abortion, but I do think that moving abortion out from under that privacy umbrella really raises some potential concerns for all other medical decision making.
Excellent point, and you're getting tons of accolades.
Oh, thanks.
There. Any other?
Yes, and obviously there's a whole lot of what's going, a whole lot of history to this. There's a whole lot in the feminist movement about women's right and ability to participate meaningfully in society if they don't have control over their reproductive, over the reproduction. But I think I wanted to put a picture of a house of cards on my slide, because that's really what the Supreme Court has done. They take something so simple like no state shall deprive one of life, liberty, or property without due process of law. And they take those words and they have turned it into this massive structure of fundamental, non-fundamental rights. Privacy is one. There are other rights that are unenumerated that get fundamental rights status. What do we mean by fundamental rights status? All of that. And then, we all like privacy. I don't think anybody wants to get rid of privacy, except maybe Justice Thomas. And so I think how are you going to get abortion out of there? And it's how they do it may be more important to me, I think, than what they do.
Great points. We have a number of questions coming in here. Okay, so whoops, chat just disappeared.
Yeah, obviously, absolutely right. So let me just dump one thing in, although I think Caroline's gonna mention this, is that if the court basically says, okay, this is not a fundamental right, we're tossing it back to the states, then we're going to have states jockeying. And so the state of New Mexico is busy, building clinics so all of Texas women can go get abortions in New Mexico. You're going to have a lot of travel involved. You're going to have, and if you look at the many prior abortion cases, there's been a lot of sort of back and forth on, well, is this really an undue burden? Well, yes, it's a burden. Is it an undue burden? How much does it really burden a woman to have to, go across state lines or to have to wait 24 hours? And that kind of, I feel like that kind of nitpicking really does a disservice to this. If it's a fundamental right, leave it alone, right? Leave it alone. But look at voting. I consider voting a fundamental right. My goodness gracious, you can only have 3 drop boxes and you have to, you can't change your voter registration on certain days. I mean, talk about regulating another fundamental right. So no, it's not, whatever the court does, we're not going to stop abortions, and we are going to have women dying, and it's going to be a bad situation, I think. But the constitutional question, or the constitutional framework, is, do we want abortion to be constitutionalized, right? And I think about prohibition, right? That was a disastrous attempt to have a constitutional amendment to outlaw alcohol, and we learned our lesson with that. We repealed it. Is abortion like that? I don't know.
Excellent points. We're going to take another question before we move on to the next speaker, and then we'll address all of the other questions trickling in here. Great questions at the end. So Dr. Dror asks, how has the precedent been defined for undue burden, and has it ever been defined as keeping in mind socioeconomic status?
So not at the federal level. States have done so. And I think Caroline's going to talk about that. States have different privacy rules. Some states have different constitutional provisions for equal protection, and have interpreted those laws differently, such that socioeconomic status, clearly it's being forced to travel across state lines is going to be an undue burden for some people. The court's general position has been, though, socioeconomic class is not a suspect classification, and every regulation is a burden on some people. So if you have to go in person to vote, that's an undue burden on you, and it's, as long as it's not applied in a discriminatory manner or done with an intention of really putting up barriers, then the laws are generally accepted. which as you can imagine, I think many of us feel that's not good.
Fantastic. Oh, sorry.
And I was going to say, yes, I can make my slides available. I'll be happy to send those.
Glad you saw that. Okay. I was going to ask. All right. Fantastic. Thank you so much, Professor Wright. Let's move on to our next speaker. Our next speaker is Professor Caroline Corbin. Professor Corbin is a professor of constitutional law and Dean's Distinguished Scholar at the University of Miami School of Law. Professor Corbin's work has been published in numerous law reviews and media outlets, and she is a frequent commentator for local and national media concerning constitutional law issues. Professor Corbin has also served as a federal judicial clerk and as an attorney at the ACLU Reproductive Freedom Project. Welcome, Professor Corbin.
I'm delighted to have the opportunity to speak with you all this afternoon. And I'm going to talk about three things. First, I'll explain federal abortion doctrine today. Second, I'll describe the Mississippi abortion case the Supreme Court has heard and the possible outcomes. And third, I will talk about Florida abortion law. Because if the Supreme Court were to eliminate protection for abortion under the U.S. Constitution, then states get to decide the legal status of abortion. And surprisingly, the Florida Constitution has more protection than the federal Constitution for abortion. So a little bit of basic con law to start, just so we're all on the same page. The U.S. Constitution is the supreme law of the land, and no law, whether federal or state, may violate the U.S. Constitution. So the U.S. Constitution always wins. Moreover, the Supreme Court is the branch of the government with the final say on how to interpret the U.S. Constitution. And that's why the Supreme Court controls the scope of constitutional protection for abortion. So what has the Supreme Court said about the constitutional right to abortion? Basically, you know that Roe v. Wade first established that the right to abortion is protected by the U.S. Constitution, and subsequent cases have modified the original decision a bit. But as of right now, there are basically two rules in terms of what is constitutional and what is not constitutional. So the first rule is that states may not ban abortion before viability. And viability, as you know, is understood as the point where the fetus could survive outside the womb. Roe enunciated this very basic rule that states cannot ban abortion before viability, and this rule has been reaffirmed by all subsequent Supreme Court cases. So that's the first rule. States cannot ban abortion before viability. Second, the second major rule is that the states may not impose undue burdens on the ability to get an abortion before viability. Professor Wright mentioned that this is the controlling rule now for evaluating the constitutionality of abortion regulations. So what counts as an undue burden? Well, specifically, the state creates an undue burden when it places a substantial obstacle in the path of a woman seeking to end her pregnancy. So the undue burden test itself has shifted a little bit, but the standard enunciated in Casey is pretty much the standard today. So again, to summarize, what is the controlling law right now is after viability, the government can regulate to its heart content. It can even ban abortion, so long as it has exceptions for women's health and life. But before viability, the government may not ban abortion, and the government may not pass regulations that impose an undue burden. Again, undue burden is defined as placing a substantial obstacle in the path of the woman seeking to end her pregnancy. And honestly, there's not a lot that imposes an undue burden according to the Supreme Court, but still it makes that analysis. All right, so that's the controlling law right now. So what is the case that is before the Supreme Court? And this is the case Dobbs versus Jackson Women's Health Organization. So in this case, Mississippi passed a law that banned abortion at 15 weeks. So while there's some dispute about exactly when viability is it 24 weeks? Is it 22 weeks? A little bit earlier, a little bit later? There's absolutely no dispute at all that 15 weeks is way before viability. So the state banned a pre-viable fetus. This is really not a complicated question for courts to decide. It is obviously unconstitutional under the controlling rule, which is no bans before viability. And indeed, both the district court and the Fifth Circuit Court of Appeals held this is a pre-viability ban. It's very clear that you cannot ban abortion before viability. This law is unconstitutional. And I say even the Fifth Circuit Court of Appeals, one of the most conservative and most hostile to abortion courts in the land, held that it was unconstitutional. It did it really reluctantly, and it still, Cohen still argued that it's a shame that it had to strike it down, but it recognized that the law is really clear about this. So the question is, why did the court decide to hear this case if the law is really cut and dried? And unfortunately, the answer has to be, it must be wanting to change abortion law. Because again, there was no confusion about the law. There was no split among the circuits about the law, which often leads the court to take the case. It really was very straightforward. It is unconstitutional to ban abortion before viability, and yet the court decided to take this case. I do not think it bodes well for the future of federal protection for abortion. So what are the possible outcomes? So the best case scenario is I'm completely wrong, and the Supreme Court wanted to take this case because it wanted to reaffirm that pre-viability bans violate the Constitution. That's hope springs eternal. That's the best case scenario. The worst case scenario for abortion is that the Supreme Court declares that Roe v. Wade was decided incorrectly and holds that the U.S. Constitution does not protect the right to abortion at all. They may decide that there is nothing specifically in the Constitution about abortion, not even about privacy. Roe was wrong the day it was decided, and it should be overruled. That's the worst case scenario, in which it eliminates protection for abortion under the U.S. Constitution entirely. Now, it might go for some position in between those two extremes. So it may say, we don't decide today to eliminate abortion, we just hold that a 15-week ban is acceptable, and it sort of cuts back on protection for abortion and cuts it back significantly, because to uphold a 15-week ban is severely restricting the rights that currently exist, but it wouldn't eliminate it entirely. So again, the case before the Supreme Court is a pre-viability ban. Up until now, that was obviously unconstitutional. It's possible that the Supreme Court will state again, pre-viability bans violate the Constitution. Honestly, very few people think that's going to happen. Really, the question is the court going to eliminate constitutional protection for abortion entirely? Or is it going to continue along its path of, as Professor Wright said, death by 1,000 cuts? And this is a particularly deep one if it upholds the 15-week ban. I don't know what the court is going to do, but the reality is there are 6 justices currently on the court who are hostile to abortion, and you only need 5 to get to a majority.
Professor Corbin, forgive my interruption. Would you push the presentation mode button on your computer?
Can you not see my slides?
We can, but we see all of them, including the ones.
Oh, I know. I like to be able to see them too for when I go through.
Oh, all right. If it's your choice, then that's fine. It's your personal liberty. Go for it.
All right. So then the question is, what happens if the Supreme Court eliminates the constitutional right to abortion? And it's important to note that even under the worst case scenario, the right to abortion doesn't disappear entirely in the United States. Instead, what happens is each state will decide for itself to what degree abortion will be protected. And some of them are very keen to eliminate abortion entirely. Many of them have what is known as trigger laws that say as soon as Roe v. Wade is overruled, abortion is now completely illegal in the state. Other states are not quite so aggressive, but have been passing their own versions of pre-viability bans in anticipation of the Supreme Court upholding the Mississippi law, and Florida is one of them. So here in Florida, the legislature passed and the governor signed its own 15-week ban. So here too, it bans abortion after 15 weeks. It has exceptions for medical emergencies and fatal fetal anomalies, but not for rape. And it goes into effect on July 1st, presumably after the Supreme Court hands down its decision in Dobbs. So Florida is ready to go as soon as the Supreme Court upholds a 15-week ban. But there's a twist in this story. The Florida Constitution specifically protects the right to privacy, and the Supreme Court of Florida has interpreted this privacy right as covering the right to abortion. So in 1980, the people of Florida approved by a vote of 60.6% to 39.3% a privacy amendment to the Florida Constitution. And it specifies every natural person has the right to be let alone and free from governmental intrusion into the person's private right. And this is now Article 1, Section 23 of the Florida Constitution. And the Florida Supreme Court has interpreted this language to protect abortion. I mean, how could it not, right? What is more intrusive into your private right than the government forcing you to continue a pregnancy? And so it said in a 1989 decision, and here's language, Florida's privacy provision is clearly implicated in a woman's decision of whether or not to continue her pregnancy. We can conceive of few more personal or private decisions concerning one's body that one can make in the course of a lifetime. Moreover, not only does the Florida Constitution not only protect abortion, it vigorously protects it. It applies a standard of review that is much more protective of abortion than the undue burden standard that you see flowing from the federal Constitution. So a good example of this is one of the laws that Professor Wright mentioned, which are mandatory waiting periods. These laws require women to wait 24 hours after they undergo informed consent before they have an abortion. And this basically requires them to go to the doctor twice. And often the informed consent is not true medical informed consent as you might understand it, but includes a bit of pro-life propaganda. And it's worth noting that other medical procedures don't require the same kind of wait. You don't have to hear your informed consent, go home to think about it and decide if this is indeed what you want to do before you can have your surgery. And it is generally understood to create huge obstacles for women who have to take not 1 day off work, but 2 days off work, have to travel far, have to find childcare, et cetera, et cetera. And of course, these kinds of laws most impact the women who don't have resources. Now, the U.S. Supreme Court applied the undue burden standard to a waiting period law and thought it was just fine, that it did not create a substantial obstacle in the path of women who wanted to end their pregnancy, and therefore it was constitutional under the U.S. Constitution. Florida has passed its own version of this, known as the mandatory delay law, requiring a 24-hour waiting period. And when the Florida Supreme Court considered this law, it didn't apply the undue burden standard, which is from federal law. It applied something known as strict scrutiny, which is really the most rigorous review you could possibly give under any constitution. And it said it didn't pass this rigorous scrutiny. So it seems like there might be a happy ending to the story of abortion rights in Florida, because as I said, not only does the Florida Constitution protect abortion, but it protects it really rigorously. It is going to subject any regulation of abortion, and certainly a ban on abortion, to the most strict kind of scrutiny. Unfortunately, the story doesn't end there, because there's one more bit to understand. And that is, just as the U.S. Constitution has taken a sharp turn to the right, so has the Florida Supreme Court. Governor DeSantis has appointed 5 of the 7 judges who are currently on the Florida Supreme Court. And so just as the U.S. Supreme Court is expected to reinterpret long-standing case law to cut back on reproductive rights, there's a good chance that the Florida Supreme Court is going to reinterpret long-standing Florida constitutional law to cut back on reproductive rights. And indeed, I think the fact that we have a much more conservative Supreme Court has emboldened the lower courts, because the Mandatory Delay Act is still winding its way up and down the courts. And most recently, a lower court actually upheld it, arguing that it didn't actually implicate the constitutionally right to privacy, because waiting an extra day is not such a big burden on the right, and lots of other states have them. And so it seems like it's just not a big deal. So you can see how a more conservative judiciary is already attacking reproductive rights under the Florida Constitution in anticipation of being supported by a newly conservative Supreme Court. Now, again, it's really hard to imagine how the Florida Supreme Court can argue that an abortion ban is not a significant burden on abortion. And even more fundamentally, it's really hard to imagine how a government-compelled pregnancy would not be considered a significant intrusion on a woman's right to be free of government interference in their right to privacy. Because again, the U.S. Constitution does not have an explicit right to privacy. The Florida Constitution does. So ultimately, the outcome of abortion protection in Florida will really turn on how unprincipled the current Florida Supreme Court is willing to be to get an outcome it might prefer. Because ultimately, the Florida Constitution does protect, right there in black and white, the right to privacy. So thank you. I'll stop there.
Thank you so much, Professor Corbin, for the wonderful presentation. We have 2 questions. We have several questions, and I'm going to try to get to every single one of them, whether right at the second or at the end after all the speakers have gone. But 2 of the questions pertain to the 15-week law that was just approved in Florida. And In this regard, Will asks how this law conflicts with Roe v. Wade. And similarly, Jessica wants to know if somebody could expand on how the 15-week law was approved exactly.
So as I know the question was asked before my presentation, so I hope my presentation went some way towards answering the question. The 15-week ban is in direct conflict to the Florida Constitution and to how the Florida Supreme Court has interpreted the Constitution, which is to say it does protect abortion, and it protects it such that any law is subject to strict scrutiny and is unlikely to survive it unless the government has a really compelling interest behind its law and that there is no other way for the government to accomplish its law. And I'm sorry, what was the second question?
How the 15-week law, if it does in fact conflict with Roe v. Wade.
That's the one I just answered, and there was a second question.
Oh, the second one, yeah, the second one was more of a general question. How, legally, what was the basis for the Congress being able to pass this law, the 15-week law?
Oh, why did the legislature pass it? It's because there are a lot of people who are very hostile to reproductive rights. And so since Roe v. Wade was decided, states have been trying to chip away at protection for reproductive rights. And so this is not necessarily a new phenomenon. It's just that it's gaining particular traction right now with the knowledge that courts would be receptive to these kinds of limitations.
Excellent. Okay, great. I know we still have some additional questions, going to get to them at the end, but want to go ahead and introduce our next speaker. Our next speaker is Professor Ciara Torres-Spelliscy. Professor Torres-Spelliscy is a professor of law at Stetson University College of Law and is also currently a visiting professor of law at American University, Washington College of Law. Professor Torres-Spelliscy has served as an expert before Congress in campaign finance matters, and her work has appeared in an array of law reviews and media. She is also the author of 2 books. The first is entitled Corporate Citizen, an argument for the separation of corporation and state, and the second is entitled Political Brands. Welcome, Professor Torres-Spelliscy.
Thank you for having me. So my presentation is going to reinforce what Professor Wright said, and hopefully this will add to your learning. So my topic today is constitutional Jenga with privacy and abortion rights. And here we go. So as we've heard a few times today, Griswold versus Connecticut is the fountainhead for our privacy rights under the Constitution. And Griswold is still controversial to this day, in part because the justices who were in the majority could not agree among themselves where privacy resided in the Constitution. And part of what they were struggling with is the Constitution is actually silent on the issue of privacy. And so there was this argument from Justice Douglas that privacy comes from the emanations and penumbra of the Bill of Rights, which are the first 10 amendments to the Constitution. And then some of his fellow justices agreed that there was a right to privacy, but they wanted to put it in a different part of the Constitution. Essentially, the other justices in the majority put it in the 14th Amendment and mostly in the Due Process Clause. And because there wasn't a clear textual peg for privacy in Griswold, it has come under withering criticism over the years, but it's Griswold that recognizes a marital right to privacy that covers the ability to use contraception. Then Roe v. Wade builds on Griswold, and Roe v. Wade is more satisfying in terms of the justices in the majority find the right to privacy in 2 separate places, One is the Due Process Clause of the 14th Amendment, and the other is in the 9th Amendment, which gives us our unenumerated rights. Just because a right isn't stated in the Constitution or in the Bill of Rights doesn't mean you don't have it. And the justices in Roe include the right to privacy as one of those unenumerated rights. And they put the right to terminate a pregnancy in the first trimester as a part of that privacy right. So with constitutional interpretation from the Supreme Court, they build on prior precedent, and they cite to prior legal precedent such that if you take out one piece of a particular way a former case was decided, it can have rippling effects. And let me explain what I mean. So if you go back to the 1940s, there is this case called Skinner versus Oklahoma. And in that case, the court was looking at the reproductive rights of men. And they were looking at an Oklahoma law that allowed for eugenic sterilization of criminals. And Skinner was going to be sterilized against his will. And he challenged that. And the Supreme Court looked at the law through the lens of equal protection, which I don't think we've referenced yet today. So the Equal Protection Clause is another part of the 14th Amendment. And the Supreme Court in Skinner said that the law, which allowed for this eugenic sterilization of criminals, was unconstitutional under the Equal Protection Clause because white-collar criminals were not subject to sterilization, but blue-collar criminals like Skinner were. And that offended equal protection. There's also language in Skinner that marriage is a fundamental right and that procreation is a basic civil right. So the court then moves on in Griswold in the 60s, and they find this right of privacy, some of the justices in the Bill of Rights and other justices in the Fourth Amendment's Due Process Clause. And then the court starts building on these two precedents. And they build on it both in the area of reproductive health as well as in the area of marriage. Now, these two things did not necessarily have to be linked, but the Supreme Court often speaks of these two rights almost in the same breath, often in the same sentence. So after Griswold, 2 years later, we get Levin versus Virginia. And in that case, the Supreme Court is looking at a Virginia anti-miscegenation law, which is also arguably a eugenics law, because the justification for having this anti-miscegenation law is to keep the purity of the white race. The Supreme Court considers two arguments from the Levings. So the Levings was a Black woman and a white man. They argued that there's a violation of equal protection because the state of Virginia was treating mixed race couples different than monoracial couples. And the Supreme Court agreed and said that that violated equal protection. They also said that this violates due process because marriage is a fundamental right. And the Supreme Court agreed with the Levings and said, yes, this is a violation of substantive due process. Then on the reproductive health side, we get Roe v. Wade. The Supreme Court says that there's this zone of privacy. It comes from both the 14th Amendment and the 9th Amendment. And this expands on the approach in Griswold and protects a woman's right to choose during the first trimester of her pregnancy. Whoops. Then in the 90s, we get Planned Parenthood versus Casey. So this was an opportunity for the Supreme Court to overrule Roe versus Wade. It's a all-male court except for Justice O'Connor. Most people thought because O'Connor had been appointed by Ronald Reagan, She was very conservative in many different aspects. They thought that she would overrule Roe, and she decided no, she was not going to be the fifth vote to overrule Roe. And so she joins together with Justices Souter and Kennedy to write the Casey plurality opinion. And they reaffirm that women have this right to choose, but they sort of drop out the Ninth Amendment analysis and rely only on substantive due process. Then back to marriage, in the 2000s, we get the court looking at the question of whether states can discriminate on the basis of sexuality. And the Supreme Court goes in a very similar vein as they had in Loving. In Windsor, they say that the federal government can't discriminate on giving out marriage or recognizes marriage between same-sex couples and heterosexual couples. That violates equal protection. They also say that marriage is a fundamental right. So you can't have the federal government interfering with that fundamental right to marry a person of your own choosing. And then in Obergefell, they build on Windsor, they build on Loving, and they decide that states also can't interfere with the fundamental right to marriage, and moreover, that states can't discriminate between same-sex couples and heterosexual couples, which violates equal protection. And that is, sorry, my slides are being a little weird here. So if the court deals with this Jenga tower, what could they possibly do? One of the things that they could do is just get rid of Casey. So if they get rid of Casey, then more recent cases that had invalidated trap laws like June Medical and Whole Women's Health would likely fall away. And that is sort of the, I think, the medium case scenario that my co-panelists have talked about. And then there is what I think Professor Wright referred to as the nuclear option. So the nuclear option is if the Supreme Court goes after Griswold, then everyone sort of hold on to your hats, because so much of constitutional law around fundamental rights, whether it's fundamental rights around contraception, fundamental rights around abortion, fundamental rights around marriage, all of those are sitting on the shoulders of Griswold. And so if you take that out, you are likely to end up with the only thing that's left is this case from the 40s, this Skinner case, which allows states to sterilize people. They just can't sterilize people in ways that violate equal protection. And that's a really scary phenomenon to think about. And so if the majority goes after privacy, this whole Jenga tower of rights is really in peril. And what's frustrating for me as someone has to teach this as a constitutional law professor is if one of my students asks me, you know, what's the difference between the day that the Supreme Court decided Russo, where they get rid of a trap law, and the day that they decide Dobbs, and the only honest answer that I can give my students is who is on the court. Ruth Bader Ginsburg really valued the rights of women. She valued privacy under the Constitution. She valued reproductive freedoms. And when she died, she was replaced by her polar opposite, who is likely to rule in the exact opposite direction. So thank you so much for listening. And for those of you who are interested in constitutional law, especially as it deals with campaign finance, which I can get to in questions if you'd like, I am always on Twitter at Prof. Ciara. Thank you. You're on mute.
That was amazing, Professor Torres-Spelliscy. Thank you so much. We have a number of questions that I'd like to get to, and any of the panels, Professor Torres-Spelliscy, Professor Corbin, Professor Wright, feel free to jump in if you feel that you kind of have something at the tip of your tongue to say about it. So Aaron asks, how do the new laws that change the burden of enforcement, quote unquote, get around those rulings? So the constitutional rulings that we've just heard about, and allow these earlier, stricter time limits?
I can start. I assume that's a question about the Texas approach. So Texas has a 6-week abortion ban, but it's not enforced by the state. This is an attempt to keep this out of the courts because without state action, you can't raise a constitutional objection to it. And instead, what they've done is outsourced the enforcement of the law to private parties and allowed individuals to sue over people violating the 6-week abortion ban, which opens providers of abortion services to an enormous amount of financial liability, I think with the intention to put them out of business.
I think what's particularly significant about the Texas law is not only that it was intentionally designed to make it almost impossible to sue anyone, but that the Supreme Court allowed it to go into effect, because all the Supreme Court had to do was enjoin it while it made its way through the courts, but it did not. And so personally, my view of how the Supreme Court was going to decide Dobbs shifted when I realized it was perfectly content to let the women of Texas have no reproductive rights for months on end, even if it was completely contrary to existing Supreme Court doctrine.
Great. Another question, Benjamin asks, although it seems unlikely, can Congress pass legislation making abortion legal, bypassing the issue of constitutionality?
I'd like to jump in on that one because there's a couple of things. Basically, I think the answer is yes, and the answer is no. It depends, which is always the answer to all law school questions. But can Congress pass a law like this? In order for Congress to pass a law, they have to do so under the Commerce Clause. So the Commerce Clause gives Congress the authority to pass legislation that involves interstate commerce. So you would think providing abortion services implicates interstate commerce. And in fact, there is a federal abortion law, the partial birth abortion ban that was upheld in Gonzales, that presumably found that abortion could be regulated by the feds under the Commerce Clause. On the other hand, if the states usually can be more restrictive, they just can't be less restrictive than the federal government. So the federal government could say abortion is legal everywhere, but they can't say states, you can't regulate abortion more harshly. So it's kind of a number of one-way streets that we have between the federal and the state governments here. But I want to throw one other piece out here. Well, actually, two other pieces out here. So one has to do with the Equal Rights Amendment. So arguably, the Equal Rights Amendment has been ratified. It's reached 38 states. It's still in litigation as to what exactly it means, but a lot of people think that the Equal Rights Amendment would actually suddenly step in if Roe versus Wade went away, because you have some states with equal rights amendments that have ruled that not providing reproductive rights services or outlawing abortions, that actually violates women's equal rights vis-a-vis men. And so if you had the Equal Rights Amendment, it's quite possible that these states now would be precluded from passing abortion bans or even abortion barriers under an equal rights theory. So it's almost like reconstituting the Jenga tower over here under equal rights. So I just throw that out as a possibility.
No, I just want to add a couple of points. I think what Professor Wright is sort of the background to her saying it has to be hooked into the Commerce Clause is, again, the basic the basic understanding is Congress has only the powers that the Constitution has listed for it. And so one of its listed powers, one of its most expansive powers, is to regulate interstate commerce. If the Equal Protection Clause is in fact valid, that's another thing that is in the Constitution that Congress can point to say we have authority to pass this law. The only thing that I worry about is that the same court who refuses to view the right to control your own body as a fundamental right under substantive due process is the same court that would interpret the Equal Protection Clause as a matter of first impression. And because the Equal Protection Clause does not specifically list abortion, it is entirely possible for this court to say it didn't mean to reach abortion. And so again, there are a lot of ifs.
I just want to jump in, Equal Rights Amendment, not the Equal Protection Clause. So the Equal Protection Clause, yeah. But you know, maybe I've got the long view. I've got the long view. You know, Plessy versus Ferguson took a long time, but we eventually, you know, found our way around that. And so maybe if this Supreme Court does interpret the Equal Rights Amendment and guts it, maybe the longer view, they'll come around to the right way of seeing it.
Congress could also do the opposite of the Hyde Amendment. So the Hyde Amendment has prevented federal use to pay for abortions, but you could use the spending power the other way and say that Medicaid and Medicare will cover abortions, and we're using our spending power, which is their other big power, in addition to the Commerce Clause power.
Excellent, productive discussion. We have one more question. And Marilyn asks, why isn't abortion considered a religious choice and accordingly treated as a separation of church and state issue?
I'm also a religion scholar, so I'll be happy. So you and I agree, as far as I'm concerned, opposition to abortion is basically grounded in religion. And for the government to codify one religious point of view and impose it on everybody else should violate the Establishment Clause. Unfortunately, our view is not the view of the current Supreme Court. And so its argument would be, even though some people oppose it for religious reasons, other people oppose it for non-religious reasons, and therefore this is not about religion at all. It's about morality, and that is something that is not violating the Establishment Clause.
Okay. Any other thoughts on that, or? Okay, fantastic, wonderful. Thank you so very much to all of the fantastic speakers. I think we've all received an amazing, in-depth better understanding of the law surrounding abortion, which is very important in this climate. I will add that we have looked for a fourth law professor panelist with a conservative legal interpretation who would support and speak to the legality of restrictive abortion laws in favor of them, but did not find one. We did find one, but was unwilling to speak. There was like one or two, but they were not available, I should say, to speak rather than willing. So it's been completely illuminating, and you know, we really thank you for coming here today and enlightening everybody with the law, which can often be very tedious. So thank you for breaking it down and making it palatable for everybody.
Thank you, Tracey, for doing such a good job moderating. To have three of the leading scholars of the law on our program has been a real treat and a privilege. And on behalf of the Florida Bioethics Network and the people who work under Florida law, thank you all.